Yes.
I make a mention of item 6, part 2, hearing list.
Yes.
It appears that there has been an agreement, settlement before the Lok Adalat in respect of the appeal,
Oh, RFA.
RFA.
Let's see. Let's see the RFA. Six. What happened? Where are you all? So both this thing are present. What are the terms of agreement?
In terms of the agreement, it's all written in Mizo.
Huh.
Lordship,
In Mizo.
if
Okay.
the matter.
Lok
is
Adalat.
placed- Yes. If the matter is placed before the Lordship in the record, under para 5 of the agreement, it has been stated that the Presbyterian Court Hanzotlang Aizol shall have to pay rupees 5 lakhs to the appellant, and those of the respondents such as Hout Sona, Zosium Apatsuo, Van Hela Patsuo, Tang Chung Nunga, and all those mentioned shall have to pay 10 lakhs.
So are you going to honor your terms of agreement? Have you taken steps?
It appears that they have made payment.
Already made payment?
Made payment.
So it's honored
It has
as
been
per
honored.
para 5, all the payment to be made. So then we'll dispose it of.
Yes, my lord.
Only thing is in Mizo. Anyway, in the order, we'll just reflect. I'll just do it now. Heard Mr. C. Lal Ramzawa, learned senior counsel for the appellant, along with Mr. Victor L. Rante, learned counsel for private respondents. Is it
5 to 9
5 to 9
and 11.
and 11? Status also, and Ms. Vane Isiami, learned counsel for the state respondents. Full stop. It is submitted at the bar that both the parties have come to an amicable settlement through Lok Adalat, through the Lok Adalat, okay, held on 13/09/2025 and registered as LA within brackets PO post close bracket number 8 of 2024. This court, okay, 2024 full stop. The learned counsels for both the parties submit that since the parties have come to an amicable settlement at Lok Adalat, the instant regular first appeal may be closed and disposed of. Full stop.
In terms of the agreement.
Disposed of in terms of the agreement reached by both the parties at Lok Adalat. Full stop. Having heard the submissions made by the learned counsels, new para, okay, from both the parties, this court has perused the award made at Lok Adalat, made in the Lok Adalat, okay, dated 13/09/2025, duly registered as LA within brackets post number 8 of 2024, wherein at para 5, is it, of the award, it has been stated that the Presbyterian Koshan, Zoutlang, within brackets, respondent number 11, is it?
Last one.
It has to be respondent number 11.
12.
12
Yes, 12.
is to pay P. Ralmanthangi / respondent number. Is it appellant or respondent?
Appellant.
Appellant, the appellant. How many appellants? One.
There are 8 appellants,
Appellant number.
but Ralmanthangi appellant number 2, she's representing appellant number 1 also.
Okay.
Zogmaya
Appellant number 2 also representing appellant number 1. The sum of rupees 5 lakhs.
Lordship, for the convenience of all concerned, if the text of the award is
Okay, in the following manner. But I just want to mention that money has already also been paid, isn't it?
yes,
Anyways,
some have paid, some have not paid as yet.
okay. But make sure that those who have not paid the money honors. Otherwise, when they don't honor the terms of the award, then trouble starts being created. The parties become. So the councils make sure that your clients honor the terms. Okay. Wherein it is seen that you cancel the last sentence. Okay. This court has produced the award wherein it is seen that at para 5 of the award, which is in the vernacular language and reproduced in vertebrum as below. Then this para 5. Oh, I think we'll get it translated. I think it will be better. We have a court translator.
We have a court translator.
Because then having an order in the MISO, it won't be, because the terms of the settlement has to be reflected by this court. Okay, we just can't dispose it of. Anything can happen later. They might want to go in an appeal also. Anyways, it is seen that, cancel all the above, okay. Then it is seen that the terms of the award is in the vernacular language. In view of the above, the said award is to be translated into the English language, and thereafter after such translation is done, the matter should be listed another day. Maybe this post off in terms of the translated award, which will form a part of the records. I don't want to fix another date. So how to dispose it off, I'm then thinking. Okay, I'll pass the order later. Okay. I'll translate it myself later. And I'll make it into this thing. Okay, we're just wasting time. It's disposed. You do it.
Well,
You leave it like that, and we'll continue later. Okay, but it's disposed. Yes.
Well, I'd like to seek Your Lordship indulgence in making a mention of part 2, item number 3. This item may be taken some of the time because I'm having 4 and 5 fixed for hearing today.
So many matters.
Knowing the fact that the matter has been pending for the past more than 7 years. So this item number 3 may be adjourned for some other day.
Okay. Not objected by the yes.
I've taken the
Mr. L.H. Elian Shima, learned senior counsel, has prayed for adjournment of the matter, which is not objected by Mr. can't hear you. Malsom Dong Zela, learned counsel, appearing on behalf of his senior, Mr. Dalbiak Nunga Namte. In view of the above, list the matter after 1 week. Is it 1 week okay?
The matter kindly be fixed on 13th of November.
Okay, in view of the above, as prayed for, list the matter on 13/11. Is it a Wednesday? No. On 13/11/20, 25. Yes.
Obliged.
For motion, item number 1. Please, your lordship. My lord, the petitioner hearing is government high school teacher appointed on 9/2/2018, and he had rendered contract under CSS prior to his appointment as government high school teachers on contract basis under CSS. Now he's claiming for counting of the past CSS service for the purpose of placement to senior and selection grade, as was given to other similarly situated employees.
Okay, will issue notice?
Yes, ma'am.
Isn't it? We'll make it short. Mr. Victor L. Rathe, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India on the for the issuance of the appropriate writ or order to the respondents, instead of order, direction to the respondents, by stating that the petitioner is a government high school teacher appointed, void order dated 09/02/2018. Full stop. The petitioner is now claiming for counting of his past contractual services as qualifying services for the purpose of placement to senior and selection grade in terms of the notification dated 19/07/2013 and corrigendum dated 02/07/2014. For allowing his past services to be counted as qualifying service, which was wrongfully denied by the state respondents via the impugned letters dated 12/02/2019 and 12/04/2024. Full stop.
2022.
2022, full stop. The learned counsel for the petitioner submits that other persons similarly situated have been
Granted.
promotion by counting their past services for the purpose of upgradation, and therefore prayed that he may be given the similar treatment as the other such similarly situated persons. Full stop. Issue notice to the respondents. Ms. Vani Siami, learned government advocate, accepts notice on behalf of the state respondents. No need to issue a formal notice. Anyone else besides
All
the state?
state.
State is
Okay.
sole respondent.
Requisite copies of the writ petition to be duly furnished to the learned government advocate. List after 3 weeks.
Deeply obliged.
For admission, item number 2.
May I please your lordship?
Yes.
My lord, on the last occasion, my lord, we have been given a final opportunity to file our affidavit, my lord. In fact, lordship, we received the instruction, my lord, due to some personal inconvenience of the council, my lord, I could not come up physically today, my lord. Some more time may be granted, my lord. Otherwise, if it is ready, lordship, we have received the instructions and it is also being prepared, my lord. It is the difficulty of the council, my lord. I am praying, my lord, some more time.
Lordship, may I take a lordship to
We'll
the
give
order,
short time, huh?
which
We'll
is
give a
dated
short time.
26/9. On the date, it has been ordered that it is seen that the learned counsel for respondents number 6 and 7 has prayed for adjournment several times for them to file their
Yes.
counter affidavit.
Though we have
In view of
said
the above, this
several
court find it
times,
fit to give final chance.
though we
they
have
have
said
been given-
several times, I have gone through the previous orders, okay? On 05/08/2025, here it says that notice upon respondent number 6 is complete, and that some council is to represent, the council is to represent respondent number 6 and 7. This is on 05/08/2025. So on 05/08/2025, the respondents number 6 and 7 were duly represented. Then, so then, in the next date, the counter affidavit was not filed. That is on 08/09/2025. So it's on one occasion. Then in the next, final chance was given. So maybe
Yes, Lordship, sufficient time was granted, my Lord.
it was
I
not
clearly, my
several times, just a couple of times, one
Right,
or
right,
two.
right. That's true.
Lordship,
Yes.
it is only because of the, my Lord, inconvenience of the council, my Lord. Otherwise, the affidavit is ready, my Lord. And in
So,
fact, my Lord,
Yes, in view of the above, we'll give one more chance.
Lord.
Though it says several times, I just looked to see how many times is that several times. And I found out that it was only on one occasion after they were represented. And in the next, we had said that several times. Okay, so maybe this court was mistaken
Lord.
by looking at the previous order. So in the interest of justice, I think we should give them a further time. Okay.
One last chance.
Yes, but since it's on the
My
verge
lord.
of being ready, I think by the next date, you'll definitely file your.
Certainly.
counter-
My Lord, we'll file our affidavit within 2 weeks, my Lord. And may I pray, my Lord, matter may be fixed on 1st of December for final disposal. I will come physically.
Okay, it can be disposed of then, isn't it?
Lord.
Because
Lord.
the matter, which I think was apprised to this court previously.
Yes,
doesn't-
Lordship. In fact, my Lord, it is a separate proceeding initiated by the Income Tax Department, my Lord. And in fact, that proceeding, my Lord, the petitioner has appeared and she has categorically stated that the money, my Lord, which was detained by the Income Tax
Let them
Department,
file
that
the
doesn't belong
affidavit.
to her, my Lord.
So wait,
Let them file the affidavit.
how come you have, how did you enter the picture? That's the whole thing.
My Lord, yes, my Lord, after receiving the information, my Lord, there was a search and seizure operation was conducted, my Lord.
And
which
whether
is-
they are bounded by the having to pay the income tax, so how have you interfered in the matter? You have to
My Lord,
clarify.
yes, my Lord, everything we have stated in our affidavit. In fact, Lordship, certainly, my Lord, they are exempted subject to certain conditions. And that condition has
Yes.
to be fulfilled, my Lord.
Who is the petitioner? Petitioner is a distinct scheduled tribe, isn't it?
Yes, yes.
Lord,
So they are not required to pay the income tax.
my Lord,
And then
what?
it appears that there's no criminal case against them. So how is it? So in your next date, please explain that.
Certainly,
Because
Lord.
we have to see whether the petitioner, as claimed by them, is being unnecessarily harassed or not, isn't it? Yes.
Lordship. Have you-
Mr. C. Ramzawa, learned senior counsel for the petitioner, is present, along with Ms. Vani Isyami, learned government advocate, and Mr.
I'm S. Chetia, Lordship, for respondent number 6 and
Okay,
7.
S. Chetia, learned standing counsel for respondent number
6 and 7.
6 and 7, who appeared through VC, full stop. It is seen that though this court in its order dated after that, before it is seen, the learned counsel for respondent number 6 and 7 has prayed for another 2 weeks' time to file his counter affidavit by submitting that the counter affidavit is at the final stage of preparation, and he will definitely make it positively, and he will positively file the counter affidavit by the next court date. Full stop. It is seen, the new part, it is seen that this court in its order dated 26/09/2025 had observed that the matter had been adjourned several times for the respondents number 6 and 7 to file their counter affidavit, for which a final chance was given to file their counter affidavit. Full stop. However, it is seen that the respondents number 6 and 7 were duly represented on 05/08/2025 by their learned counsel, and on 08/09/2025, the learned counsel for respondent number 6 and 7 had prayed for time to file their counter affidavit. Thereafter, on 26/09/2025, this court had given final chance for the respondents number 6 and 7 to file their counter affidavit. In view of the above, since only 2 occasions, since the matter had been adjourned on only 2 occasions for the respondent number 6 and 7 to file their counter affidavits, this court find it appropriate in the interest of justice to give another chance to respondent number 6 and 7 to file their counter affidavit. Accordingly, as prayed for, list on
My lord, 1st of December, Lordship.
010.
Why not in November, Your Lordship?
Yes,
Because-
you said it will be ready by 2 weeks.
By
Then
2 weeks.
Yes, yes, my lord, we'll file our affidavit within 2 weeks, my lord. Let the matter be for final disposal on 1st of
Okay,
December.
okay. In view of the above, list the matter on 01/12/2025, by which date the learned counsel for respondent number 6 and 7 is to file their counter affidavit duly, and copies to be duly furnished to the learned counsel for the petitioner, and the matter may be listed for filing the hearing on the matter may be taken up for final hearing on the first 12, 2025.
Your Lordship,
Yes.
in the interest of justice, if the matter is the final stage of preparation, and if they are ready within a 2 weeks' time, let them
Yes,
file.
my lord.
Let them
My
file
lord,
within
we'll
2
file our
weeks.
affidavit within 2 weeks.
Let them
Okay.
file within 2
So
weeks, so that we'll
I'll
have.
include that later, is to file the counter affidavit within 2 weeks. Okay, in the previous order somewhere I'll
We
include.
may
that.
like to file a reply also,
Lordship, yes.
so that
Yes.
the proper opportunity is
Okay.
given to the
Okay,
petitioner.
just add the counter affidavit by respondents number 6 and 7 is to be filed within 2 weeks' time,
2 weeks.
wherein the petitioners may also file their reply to the counter affidavit. So accordingly, fix 1/12/2025 for a final hearing of the instant criminal petition. Yes.
No, please.
We'll make a
Deeply
few
approved.
corrections, but that's a gist, yes.
I am obliged.
For orders, item number 3.
Yes.
Lordship, I
Correction made with the index, whatever, what,
Copy, my lord,
I
not
was
served
to
to me.
furnish the copy of the correction, but my lord haven't received yet.
index has not been, rest is okay, isn't it? It's only in the index. So now, the index is correct. Have you cross-checked?
I
Have you
have
both
received-
cross,
I have
you have
received the
received,
correct-
have you
yes, ma'am.
cross-checked?
The-
Okay, but the corrected index is not, this thing furnished to you, is it?
My lord, yes, I haven't received.
Anyway, then after that, what is the stage? Can it be listed for
For
hearing
hearing.
thereafter?
For hearing.
Okay. Mr. Victor L. Rate, learned counsel for the appellant, is present, along with Mr. C. Zoram Chana, learned counsel for the private respondents, and Ms. Vani Isyami, learned government advocate for the state respondent. Full stop. The learned counsel for the private respondents submits that he has not been furnished with the copy of the corrected index in terms of this court's order dated 08/10/2025. Accordingly, the registry to do the needful thereafter, since all the parties have been duly represented. Oh, wait, has the matter been, this thing admitted? Appeal should be admitted? Yes, represent, and the matter has already been admitted. This case may be listed for hearing as per its, in the usual course, as per its own term. Yes.
Item number 4.
My lord,
Yes.
as the TCR has been received by the registry, the registry may be directed to prepare paper book at the expense of the applicant. Paper book will be required.
Okay. Mr. L.H. Ganshima, learned senior counsel for the appellant, assisted by Ms. Rutlal Rotfali, learned counsel. Wisdom. It is submitted that a TCR is received in view of the above as prayed for. The registry is to prepare the paper book at the expense of the learned counsels, at the expense of the appellants. Okay. So, thereafter, copies of the paper book to be duly furnished to both the parties, and the matter may be listed for. Has it been admitted? Okay, no.
Already, madam. It can
let
be
me
listed
see.
for hearing, madam.
Wait, let me see. When was
Already
it?
admitted this.
Where?
in
On
the
which
last-
date? Let's see. No, it's not mentioned. So we'll list another date at the expense of the, we have said that, isn't it? At the expense of the appellant. List the matter after 2 weeks.
My lord. Right.
Item number 5.
Lordship, in the last quarter, we were directed to have a address, correct address of respondent number 2. So we were unable to have the correct address of respondent number 2 because respondent number 1 and respondent number 2 were divorced, and respondent number 1 didn't know the correct address of respondent number 2. So, Lordship.
So you have to get the correct address of which
Yes.
respondent?
Yes, Lordship, if I may be allowed to.
Respondent number,
the-
correct address of respondent
Respondent
number?
2.
2,
Yeah.
okay.
Lordship, if I may
What
be
time?
allowed to, the newspaper publication for,
No, where they're staying? What is the address? What was their previous address?
Tuikwal.
To equal, then do a little bit of your homework, isn't it? Find out the address, then you can serve notice through Dusty. It's in Mizoram. Because you can find out from respondent number 1 also.
We asked him and he didn't know the correct address of, because she is not staying in Tuikwal North anymore.
So it's not such a big place. You find out. Let the respondent, the applicant, do a little bit of homework. Find out from the local leader. So isn't it?
Yes, Lordship.
Make another attempt. I don't think you have really made a serious attempt to find out the address of respondent number 2, isn't it? Let the applicant find out. It shouldn't be so difficult. Unless you get a letter from the locality where he was previously staying, so that the whereabouts cannot be known or whatever, something show that simply asking respondent number 1 might not suffice. Heard, Miss
Larimrati Rentle.
Lalrembroti Rentle, learned counsel for the applicant who has prayed for further time. to obtain the correct new address of respondent number 2, and thereafter service of notice may be made through the corrected address. Praise aloud the learned counsel for the applicant to take necessary steps. List after, how long will it take? 3 weeks?
3 weeks. Yes.
3 weeks, full stop. The presence of Ms. Vane Isiami, learned government advocate for the state respondents, number 3, is it?
Yes,
Is noted, yes.
Obliged.
Item number 6.
May I please, Lordship? My Lord, this is an application for substitution of the respondent number 5, who died on 11/4/2025,
Substituted by?
by his son, my Lord. I have enclosed a copy of the death certificate as well as the ration card, my Lord. In fact, it was he who furnished the copies of the death certificate and the ration card, my Lord. Address of the son is also given there.
I think we can allow Mr. L.H. Liam Shima, learned senior counsel for the applicant, assisted by Mr. Ruth so-and-so, learned counsel, full stop. This is an application filed under Order 22, Rule 4 of the Civil Procedure Court for substitution of respondent number 5 in the connected RSA number 3 of 2025 by
His son,
his son who
Samuel
or, by his son, since the respondent number 5, Mr. what's his name?
Lalkamlova,
Lalkam Lova, died on
11/4.
11/04/2025, and his son Sri Samuel Lal Rohlua is the legal heir of the respondent number 5. Notice be issued. Full stop. Ms. Vane Isiami, learned government advocate, accepts notice on behalf of the state respondents. Full stop. This court, considering the nature of the application, may find it appropriate at this stage to allow the application, since no objection has been raised by the learned government advocate. Accordingly, Mr. Lalkam Lova arrayed as respondent number 5 in the connected RSA number 3 of 2025 is to be substituted by his legal heir and son, Sri Samuel Lal Rohlua. Resident of Zone 1, Aizot. Opposite to UPC, is it?
Yes, madam.
UPC General Headquarters Building in the connected RSA number 3 of 2025. Stop. Accordingly, IA number 174 of 2025 stands allowed and disposed of. Yes. Then in the main RSA, on
There
the
is another, my lord,
IA.
there is another IA.
what is this IA?
This delay.
Oh, so
Delay in
this
filing
has
this
to be disposed of first, yes.
Yes, madam.
Then in the IA number 56 of 2025, okay. On the disposal of IA number 174/2025, allowing the substitution application. You have to change your cost title. A cost title in the connected IA number 56 of 2025 and the RSA and the connected RSA number 3 of 2025 is to be duly corrected by the Learned Counsel for the applicant/appellant. Thereafter, this is the matter. After, how long will it take? 1 week?
1 week will do.
This is a matter after 1 week. You change the cost title first and then see next steps. What is the condemnation? Was notice issued?
Notice was issued.
Already issued. Then let the cost title be changed first.
My lord.
Part 2 hearing, item number 4 and 5.
Mac appeal. Yes. There's a cross objection also. Is that regarding the judgment?
I please, Lordship. Lordship, this is the second round of appeal. And the first mic appeal was registered as appeal number 28 of 2019 against the impugned judgment and award dated 12/6/2019, and which was allowed by this honorable court, and it was remanded back to the Learned Tribunal, and it was set aside the judgment and award, and it was remanded for de novo trial. And the Learned Tribunal passed this impugned order on 2/9/2024 by
You can
adopting
go and come back later. Yes.
by adopting all the evidence earlier adduced before the Learned Tribunal, Lordship. And Lordship, at the time when the matter was remanded back by this honorable court, and it was clearly stated that a de novo trial will be conducted. But however, instead of taking a new evidence, the Learned Tribunal had adopted the earlier evidence, which was already set aside, Lordship. And also there are as many as 4 witnesses, and the claimants, CW number 1 is the father, and CW number 2 is the inquiry officer, and CW number 3 and 4 are the
Anyway, where is the judgment
Lordship,
of this court saying that the novo trial has to
Lordship,
be?
yes. Take Lordship to page 12 of this my appeal, Lordship. Page 12. And the operative is from page 18, paragraph number 18, Lordship.
Okay, now previously, so page 22, para 26,
Lordship, yes.
it should be remanded back for having and by impleading the driver.
The driver,
So did the driver, this thing appear before the court?
no, it's not appear. It was impleaded driver and owner of the vehicle, but however, they didn't appear, Lordship.
So de novo trial was ordered only because the court felt that the driver and the owner should also be made a party.
Not only, Lordship, rash and negligent was not proof. That is, may the Lordship to page 18, paragraph 18, in order to make the case clear, Lordship. In the case of such and such reported in such and such, Lordship, the Apex Court has held that rash and negligent act on the part of the driver, owner of the vehicle, has to be proved before the compensation can be awarded. Since it also this is under 166 of the MV Act. So in the present case, no eyewitness to the accident has been examined. Neither has any statement of any eyewitness to the accident been submitted before the learned tribunal. The police report dated 05/08/2017 issued by the officer in charge Vivacon Police Station does not give a description as how the accident occurred. The report only states that the accident happened due to rash and negligent driving on the part of the truck driver and that Vivacon Police Station case number such and such under had been registered. The evidence of ASI Sri Lalmuan Sanga CW number 2 is that the bike ridden by Sri Lal Thianghima with pillion rider Sri Kelal Ruatpuya coming from Rangbamual was dashed by a truck coming at a high speed from Bongkon. Though bystanders tried to stop the truck fled from the scene. However, the truck driver surrendered with the vehicle at about 11 p.m. at Vivacon Police Station. CW number 2 further states that from the statement of the witnesses and from the circumstances of the accident, it is evident that had the driver been careful, the accident could have been averted, as the truck driver could see the bike coming from the opposite direction and giving proper signal. CW number 2 thereafter stated that the accident was purely due to the rash and negligent driving of the truck driver. CW number 2 also states that he did not know the outcome of the Vivacon Police Station case number such and such under section such and such, which was registered against the driver of the truck. On bare perusal of the evidence of the CW number 2, it is clear that CW number 2's evidence is based on what he has heard from the alleged witnesses to the accident. However, no eyewitness to the accident or the witnesses from whom CW number 2 had spoken to have been specified or brought to the court for giving evidence. No statement of alleged eyewitnesses to the accident have been submitted before the learned tribunal. The evidence of CW number 2 that the driver of the truck could see the bike coming from the opposite direction and giving proper signal also give rise to an inference that the converse would also be true. That is, the bike rider would also have seen the oncoming truck. As stated earlier, the police report dated 5/8/2017 does not specify as how the accident occurred, whether the accident was a head-on collision or whether the bike hit the side of the truck, whether the road was wide and narrow, whether there was a curve in the road, which part of the truck was hit by the bike, and vice versa. In a claim under Section 166 of the MV Act, it is the duty of the claimants to prove that there was rash and negligent act on the part of the driver, owner of the offensive vehicle. This court, however, finds that there has been no evidence produced before the tribunal proving that the accident had occurred due to rash and negligent act on the part of the driver. So that is the findings of this Honorable Court, and paragraph 22 is relevant, Your Lordship. A perusal of the above facts shows that while a case of rash and negligent act has been made out by the police in Vivacon Police case number such and such against the driver of the truck, the police have also made out against the driver of the bike under Section 181/196 of the MV Act 1988, as the bike rider could not produce his driving license and insurance certificate. This aspect of the case has not been brought to the notice of the learned tribunal by the respondents, claimants, and even by the police during recording of evidence. The evidence of the witnesses is only to the effect that there was rash and negligent act on the part of the truck driver and have come conveniently kept silent in the status of criminal case. This court finds that the respondents number 1 to 4 and CW number 2 have not been truthful, frank, and open with the learned tribunal. They are playing hide and seek with the tribunal and thereby opening up an avenue for abuse of the process of the court. Fraud should not be allowed to be perpetuated by any witness with the learned tribunal, especially the police, which is case is CW number 2. In the case of such and such, the apex court has held that no court or tribunal can be gathered as powerless to recall its own order if it is convinced that the order was wrangled through fraud and representation of such a dimension as would affect the very basis of the claim. Interestingly, the owner of the bike and the rider have not been made parties before the learned tribunal. There is also nothing to show that the bike driver, Sri Laltiang Lima, had a driving license to drive a bike at the relevant time. A question arises as to whether the bike rider was rash and negligent by driving a bike without having a driving license. This court is of the view that besides proving of the rash negligent act of the against the driver of the truck, what will also have to be decided is whether the driver of the bike was rash and negligent by driving a bike without having a license for the same, and whether the said act endangers the life of others. In view of the above reasons, this court is of the view that the present case is not with regards to this court taking a hyper-technical approach to the case in hand, but is with regards to certain facts being suppressed in the evidence by CW number 2 and CW number 1 and CW number 2 for reasons best known to them. This court is accordingly of the view that the judgment of the apex court in such and such is not applicable to the case in hand. In view of the reasons stated above, this court finds that the evidence adduced and the documents on record before the learned tribunal does not conclusively prove that there was any rash and negligent act on the part of the driver of the truck. Assuming that there was some rash negligent act on the part of the driver of the truck, or the further question has to be decided is whether the onus of paying the entire compensation could have been fastened solely upon the appellant, inasmuch as the learned tribunal was not made aware of the fact that criminal trial number such and such arising out of Vivacon police case number had also been filed against the bike rider Sri Laltiang Lima, who did not have a driving license. The question of whether the bike rider was guilty of contributory negligence would thus have also be seen. This court is accordingly of the view that the case should be remanded back to the learned tribunal for having a de novo trial, and by impleading the driver of the motorbike Sri Laltiang Lima and also the owner of the bike. Accordingly, this court remands back the case to the learned tribunal for a de novo trial as per the observation and direction given above. This court is not inclined to go into the other issues raised by the appellant, as the said issue can be decided afresh in a de novo trial. Consequently, the impugned judgment and award dated such and such passed by MSCT Aizol in MSCT number is hereby set aside. So, this honorable court had already set aside the earlier evidence adduced before the learned tribunal, Lordship. However,
No, maybe further evidence is required.
yes,
Anyway,
further evidence is required. But here in this case, no further evidence was taken. And the already set aside evidence was again adopted, Your Lordship. So that is one of the main grounds.
So what did the trial court decide in the present impugned order?
Lordship, yes.
What did it say, that there was rash and negligent driving, or
Lordship, yes. Just, and which is at page D, Lordship, page D. And Lordship, may I take Lordship from page C, paragraph number 3. Paragraph number 3 is in compliance with this honorable court order, 2 additional issues were framed by the learned trial court. And number 1 is whether the bike rider Laltiang Lima, the OP number 4, was guilty of rash negligence by driving the bike without having a license for the same, and whether the said act endangers the life of others. Number 2, whether the bike rider was guilty of contributory negligence. That has been framed additionally in compliance with this code. And as of the findings is on the next page, paragraph number from 6, may read from 6. The issue already decided by my predecessor is hereby adopted. As such, both the parties also agreed, and regarding the 2 additional issues, I am of the opinion that the 2 issues, whether which I've already read out. As regards to issue number 1, it is evident that the bike rider Lal Thiang Lima implemented as OP number 4 was riding his bike without a license, which is clear as this tribunal had issued numerous summons but failed to appear, and newspaper publication for 3 consecutive days was also made, but still failed to appear before this tribunal to submit its defense and submit his driving license. And further, from the record of the criminal code, it is clear that he did not possess a driving license, and further, it is clear that riding a vehicle without a license amounts to contributory negligence, and as such, I hold the OP number 4, Lal Thiang Lima, as committing contributory negligence in causing the accident, inasmuch as he drove his bike without a valid driving license at the relevant time. As such, these 2 additional issues are decided against the claimant. Coming to the compensation, as negligence was proved by the claimants by producing the police, namely Lal Muan Sanga, SI of police. His evidence cannot be discarded, but newly implemented OP number 4, having committed contributory negligence by driving his bike without a license, in my opinion, liable to pay 20% of the amount so calculated. And having gone through the evidence adduced, and on hearing the parties, the insurance was valid at the time of the accident, which is not denied, nor was it in its pleadings before the tribunal and in the High Court, and as such, I hold the insurance liable to pay 80% of the awarded amount to the claimants, as the vehicle bearing registration number such and such was valid at the time of the accident, and further negligence was proved by producing evidence. And as such, the negligence of both the drivers of the ratio 70:20, the opposite party number 3, national insurance, is directed to deposit such and such, that is 80% of the compensation, and the OP number 4 is also directed to deposit such and such only, that is 20% of the compensation, along with 7% per annum from the date of filing from 1 month. That is the findings. However, in this case, the learned tribunal had again used or considered the CW number 2, that SI Lal Muan Sang, as evidence for making a proof of the negligence, which is already set aside by this Honorable Court, Lordship. Which I have read out, Lordship, which is a para 25 of the dishonorable court or judgment, which has been clearly says that the tribunal does not conclusively prove. We take Lordship again to the page 21. Paragraph number 25, Lordship. In view of the reasons stated above, this court finds that the evidence adduced and the documents on records before the learned tribunal does not conclusively prove that there was any rash negligent act on the part of the driver of the truck. So
you're representing whom? The insurance,
National
isn't
Insurance
it?
Company, Lordship.
And the truck was insured with the national insurance. is
Yes,
it?
Lordship, yes.
So you're saying that you are not liable to pay any amount.
Lordship, yes.
That's
because-
your main ground. So
Yes. This is under 166. So the burden is on the claimants to prove that there was a rash negligence on the part of the driver or on the part of the owner, Lordship. But they have produced only one witness in order to prove rash negligence, which is the CW number 2, the police. and the police evidence was not a conclusive proof by this honorable court judgment, Your Lordship. So, as per my understanding, Your Lordship, the
So at least some additional evidence.
yes, that is required. This is what this honorable court had also said so. So it was remanded back to the learned tribunal to have a fresh de novo trial, which has been clearly reflected at paragraph number 26 of this honorable court judgment. But instead of producing any additional evidence, it was adopted the earlier evidence, which is already set aside by this honorable court, Lordship. So, Lordship, in this case, I'd like to rely on the authority 2012 4 SCC 552, 2012 4 SCC 552, paragraph number 9 and 10.
Yes,
May I read, Lordship?
yes.
Admittedly, the petition filed by the claimants under Section 166 of the Act and not under 163A of the Act. This is not in dispute. Therefore, it was the entire responsibility of the parents of the deceased to have established that respondent number 1 drove the vehicle in a rash and negligent manner, which resulted in the fatal accident. Maybe in order to help respondent number 1, who is the driver, Lordship, in this case, the claimants had not taken up that plea before the tribunal. Therefore, the High Court was justified in subsisting the judgment and order passed by the tribunal. We make it clear that if for any reason the claimants had filed the petition under 163 of the Act, then the dicta of this court in such and such would have to come to assist the claimants. In our view, the issue was that we have raised for our consideration is squarely covered by the decision of this court in such and such. Therefore, the victim of the accident or his dependents have an option either to proceed under 166 of the Act or under 163 of the Act. Once they approach the tribunal under 166 of the Act, they have necessarily to take upon themselves the burden of establishing the negligence of the driver or owner of the vehicle concerned. But if they proceed under 163A of the Act, the compensation will be awarded in terms of the schedule without calling upon the victims or his dependents to establish any negligence or fault on the part of the owner of the vehicle or the driver of the vehicle. Now, this has been filed under 166 of the MV Act, and it is mandatory to prove that there was a rash negligence on the part of the driver or owner of the vehicle. Also. And another.
But the reasoning weighed in this instant case, the tribunal, is it the same reasoning given by the court previously? It's relying on the same evidence,
Relying
isn't
on
it?
the same,
Same
yes,
evidence.
evidence, you know,
But the reasoning given as to why it is relying on the same evidence,
that was not
finding
reflected.
the truck, the saying that there was contributory negligence on the part of the truck, isn't it?
Lordship,
Truck
yes.
driver. Is it the same? Or maybe the court, when considering the matter de novo,
Do you know?
looked at the evidence in a different angle?
Lordship, maybe yes. But as per my understanding, Lordship, the de novo trial has been explained by this honorable court. In the case of Lordship, it's in 2017. This is different one. I'll
Please
Yes.
give it to me.
yes, 2017 12 SCC regarding the de novo, Lordship. I'll come to that one later, Lordship. 2017 12 SCC 699,
Section 166, 163, that judgment is not required.
not required.
If you are coming to that same point, then it's not required.
Lordship, yes, that may
Because
not be-
166, you have to prove rash and negligent driving, huh?
Lordship, yes. Operative is from paragraph number 11 and 12. 11 and 12. May I read, Lordship?
Yes.
Though the word retrial is used under section such and such, the power conferred by this clause is to be exercised only in exceptional cases where the appellate court is satisfied that the omission or irregularity had occasioned in failure of justice the circumstances that should exist for warranting a retrial must be such that where the trial was undertaken by the court having no jurisdiction or trial was vitiated by serious illegality or irregularity on account of the misconcept of nature of the proceedings, an order for retrial may be passed in cases where the original trial has not been satisfactorily for some other particular reasons, such as wrong admission or wrong reject of evidence, or the court refused to hear certain witnesses who were supposed to be heard. De novo trial means a new trial ordered by the appellate court in exceptional cases where the original trial failed to make a determination in the manner dictated by law, Lordship. The trial is conducted afresh by the court as if there had not been a trial in the first instance. Undoubtedly, the appellate court has the power to direct the lower court to hold de novo trial, but the question is when such power should be exercised. Lordship, that is the, and as per my understanding, Lordship, the learned tribunal had to have a fresh trial, Lordship, instead of adopting the earlier evidence adduced before the learned tribunal. Here, the Supreme Court clearly says that.
No, but if the same witness is this thing called and this witness gives the same evidence, then
Evidence. Lordship, here it says that the trial is conducted afresh by the court as if had not been a trial in the first instance. I think, as per my understanding, Lordship, the
no, but
dishonorable
then,
court had given a
calling
chance
the
to
same, calling the same witness who will depose the same thing, that would
and Lordship, as per my understanding, the dishonorable court had given a chance to the claimants, saying that because it clearly says that Ras
but they can
negligent was
always
not.
give some additional
Yes,
evidence.
yes, additional evidence in order to prove that Ras negligent. So they can call the same witnesses also, then they can rectify what they have not done earlier also. But that was not done. That was not done. So this is my understanding. I think the dishonorable court is very lenient.
Let's see the order sheet.
Lordship.
No, of this thing, TCR. So after the matter was remanded back, when was it remanded back? By the order number? Dated?
Lordship, it's remanded. Was it 9/11/2020?
From the TCR, my lord, 11/11/2020. That is the date when the order was
11/11, huh?
11/11/2020.
So lots of steps were taken, huh? 11/11/2020. Then received back and then for further proceedings. So reissue summons to opposite number. So opposite number 4 has been
They are the newly impleaded parties, Lordship. Not the
Adjourned.
earlier this.
WS by then for WS by respondent number 4. Newspaper publication.
Newspaper publication was on 23/23. Issue summons to the said office through newspaper publication.
So basically, it is awaiting for the. Now I'm just seeing whether the opportunity was given for the parties to adduce fresh evidence or further evidence.
My lord, in that connection, I would like to take your lordship to order dated 27/23 of the PCR. Order dated 20.
Yes, President, I have agreed to adopt also,
is
have amicably agreed to adopt all the evidence already adduced by the witnesses.
All the evidences have been
So
adopted.
they both this
Yes.
thing have said that they don't want to adduce further evidence.
Lordship, as per my understanding, that is an advantage of the insurance company, because if no
Advantage?
new, advantage in the sense that if no new additional evidence has
So
been
you're the
adduced,
insurance
I'm
company,
the insurance
then
company.
good enough.
Advantage in the sense that, Your Lordship, since there is no new additional evidence, so the rash negligent was already not considered in the sense that that was not proof as per this honorable court order, Lordship. So they
So
have
you're
to
saying that you
adduce additional
cannot come a
evidence.
finding, cannot come to a finding which is not in consonance with the observation made by this court.
Lordship, yes, that is my understanding. And instead of adducing the additional evidence, and it was
So both
strongly
the
adopted.
parties have agreed, huh? So you harp on the point that, so since both the parties have agreed no additional evidence, therefore, the trial court should, this thing, adhere to the finding made by this court, isn't it?
Lordship,
I
yes,
think
yes.
that's your point.
That's my point, Lordship. Since rash negligence was not proved, that was the finding of this honorable court.
So it
was-
cannot go against the finding.
Lordship, yes, yes. So the learned tribunal failed to comply with this honorable court. And Lordship, and presuming but not admitting, Lordship, if this appeal is allowed, and regarding the income of the deceased, my point number 3 is regarding the income of the deceased. My point number 1 is regarding rash negligent, and second one is regarding trial de novo, and the third one is income of the deceased. And the deceased was stated that doing a business of distributing betel leaves in the Aizawl South area, betel leaves in the South area, and they have produced 2 witnesses, CW number 3 and CW number 4, and they have stated that they are also working as a doing a business of distributing betel leaves, and they do not know the exact income of the deceased. So the income of the deceased also not proof. So they have stated that 25,000, not let the deceased earn not less than 25,000, which has been in the judgment, judgment and award passed by the learned tribunal, and that was a
Let's see the
presumption.
judgment and award.
Yes, Lordship. That has also to be
Read
additional.
para, which para,
A paragraph number, Lordship, that is
page?
page, Lordship, that is in the judgment, earlier judgment. I have not annexed in the,
If you have not annexed that, then how can we see?
in the earlier judgment, Your Lordship, because as per understanding, the learned tribunal has to elaborate all the evidences, but
So
instead
enclose
of
the
that-
earlier judgment also. If we cannot see the earlier judgment,
Lordship, yes.
how can you make your argument?
And
isn't it?
the
So we'll fix another date. You enclose the earlier judgment by filing an additional affidavit. It's not complete. See, you're referring to the earlier judgment, which is not there in your, this thing, appeal. And you're raising the point on the income.
right, Lordship,
Then how can we proceed? Isn't it?
It may not be proper to refer to the earlier judgment if it is not available on record, my lord.
No, if you're going to refer, then we'll fix another date. You make a then copy will be given, and then we'll see. Because in the income, if you're going to, or you leave that, this thing. So in your appeal petition, have you mentioned that?
yes, Lordship, in the grounds of appeal, I have mentioned. which is
Then,
paragraph number
then why
3.
didn't you enclose the earlier judgment?
Lordship, here,
That should be available on record. simply referring to something which is not there for perusal, we cannot consider. So we'll fix another date. Call the this thing.
Well, we are almost there, almost through.
But, we cannot continue because the earlier judgment, he wants us to browse through the earlier judgment concerning the income. So it should be there on record. Yes, have you called? So you can file an affidavit to bring on record the judgment dated so and so and so and so. And then we can list the matter again for hearing. Now,
as part of
anything, that will have to take some time. Part of it will be a long time. So we'll fix another date.
At least let the matter be fixed as part of, my lord.
No, part hurt will be a problem because this court will not be sitting for some time after the weeks.
My lord,
Then
then
the
also
whole
is it-
thing from the beginning with us, then we don't remember, isn't it? Part
lord.
hurt will be after 1 or 2 days, then its memory is still.
Right, my lord. In any case, we shall have to refresh our memory.
Yeah,
So,
with the earlier judgment also, you'll have to
Ma'am.
look also. But why didn't you enclose that if
Lordship.
it's there in your appeal? If you
Yes, Lordship,
mention
as
the
per my
earlier.
understanding, Lordship, that has to be, it's already closed. The chapter was already closed.
Then
But
why you
however, in the
referring that-
subsequent judgment, Lordship, in the subsequent judgment passed by the learned tribunal, so it was adopted, just simply adopted, saying that the national insurance company is directed to deposit. So no
Okay, so
calculation.
Then we'll have to
nothing.
see the earlier
Yes.
judgment.
Nothing is there, no calculation, and one calculation is also miscalculated. That also I have.
So how do you know that it is based on the earlier judgment?
It's there, Lordship, in the earlier judge here in this impugned judgment.
It mentions the earlier judgment.
Not earlier judgment. It was simply said that as such, the national insurance company is directed to deposit. That's it. No calculation. At least it should be a fresh calculation.
So you don't mention, you can say that the award has to be set aside because no calculation is made. So in this thing, you're saying this
That page E,
Where is
Lordship,
it?
paragraph 8. Page E, paragraph number 8.
So how do you know that this is the calculation done based on the earlier judgment?
Because it is exactly similar, 39,55,000. It's in the earlier impugned judgment and award. It was calculated 30.
But since it didn't mention the earlier judgment, you have a good case then. This thing calculation made is also not based on anything. That also you can
Yes,
see,
yes, that's also one of my points.
isn't it?
even if the the impugned judgment and order passed by the tribunal was similar to the earlier one, it is no wonder because the parties, the councils, both councils have agreed to adopt all the evidences adduced by the rival witnesses,
So the earlier
on.
judgment is required,
my lord.
isn't it? Anyways, heard Mr. Johnny L. Tochong, learned counsel for the appellant, along with Mr. L.H. Lianshima, learned senior counsel for the respondent, assisted by Ms. Ruth So-and-so, learned counsel for staff. On hearing the submissions made by the learned counsels, it is seen that, instead of that, the learned counsel for the appellant has prayed that he may be allowed to file an additional affidavit to bring on record the judgment Dated
12/6/2019.
12/6.
Judgment and award. 12/6/2019.
Judgment and award 12/6/2019 in MAC case number
In case number 28 of 2019.
28 of 2019. No.
MSCT number 53 of 2017.
Okay. In which was passed by the
MSCT.
learned tribunal in the earlier round in MAC case number 53 of 2017. Since the said judgment and order is necessary to consider the instant MAC appeal. First, the learned counsel submits that in the previous MAC case number so and so, the previous, okay. The learned tribunal has made the calculation of the income of the deceased and also the award
Also, future prospect is also wrongly calculated.
and the awarded amount to be given to the claimant, which has been simply adopted in the later MAC case number 53/2017. In view of the above submissions, in the interest of justice, this court finds it appropriate that the learned counsel for the appellant may file an additional affidavit bringing on record the said MAC case number so and so, okay?
53 of 2017.
23 of 2000 so and so. 2017.
2017.
Accordingly, list the matter after. No, accordingly, this matter, this case is released from hearing column. We'll let the release it, okay, and be listed under orders. List the matter after 3 weeks.
Obliged.
You should have thought of that before now at the later stage, but then if you find it important, it's okay.